guys, it's Kathy. I hope you're doing well. Kristen told me I need to look at Minnehaha today, so obviously I did. Hopefully we got the one that she was thinking about. We got some, listen, they don't play around in South Dakota. They just do not play around. So some of it is a little graphic, you'll see, but it ends with a bang, that's for sure. Here we go. I turned the volume down a little bit because it's a bit loud.
Hope you got.
I do.
Right.
Thank you.
Good afternoon, everybody.
And actually, I'm going to skip it through this first part because it's boring. He's giving everybody their rights at once. Here we go.
Questions about the facts or details of your case? As you have the right to remain silent, this hearing is being recorded, and any admissions you make on the record here today can be used against you at a later court date. Sandra, let me know when they're ready.
Okay, we need
Yeah.
to
Right.
fill out another
Thank you.
application.
Mark Sededal or Slededal?
¿Dónde dijo que trabajaba? ¿Qué es lo que hacen ellos?
This is State of South Dakota versus Mark Slededal. It is court file 258897. Sir, were you present when I advised you of your rights?
Yes.
And did you understand those rights?
Yes, I did.
In this file, you're charged with criminal trespass. It's a class 1 misdemeanor in this case, and it carries a maximum potential penalty of up to a year in jail and or $2,000 in fines. Do you understand that charge?
Yes, I do.
Then in the other files, court file 257377, 8544, and 8659, you're here on warrant hearings. Looks like you missed a pretrial conference on December 31st where a bench warrant was issued for your arrest. I show you previously been advised of those charges. I won't re-advise here today. Public Defender's Office has been appointed on those other files, and I'll appoint them to the new file here today.
Accept appointment, waive reading and advising.
Thank you. State's position on bond.
No objection to a PR. Would request pretrial services given the number of files.
This will be a PR bond on conditions of good behavior. Stay in contact with your lawyer, make all court appearances, and that you comply with pretrial services, and that you be personally present at all of your court appearances going forward. Right? With that, you'll be released later today. Thank you. Emily Whitesell. I'll be appointing Emmanuel Miller to the Public Advocate's Office. Please share discovery.
And she needs private counsel.
Emmanuel Miller.
No, White Cell.
Okay, thank you. And Ms. Hofer, let me know when you're done with that and ready to.
There was an affidavit, so I'm ready.
Oh, okay. I'll take Whitesell and then I'll take you after. This is State of South Dakota versus Emily Whitesell. It is court file 26100. Ma'am, were you present when I advised you of your rights?
Yeah.
And did you understand those rights?
Yeah.
You were here today charging count 1 with possession of a controlled drug or substance in Schedule 1 or 2. The named drug being methamphetamine. It's a Class 5 felony and it carries a maximum potential penalty of up to 5 years in prison and or $10,000 in fines. In count 2, you're charged with possession of marijuana. It's a Class 1 misdemeanor. It carries a maximum potential penalty of up to a year in jail and or $2,000 in fines. In count 3, you're charged with possession of drug paraphernalia. It's a Class 2 misdemeanor. It carries a maximum potential penalty of up to 30 days in jail and or $500 in fines. Do you understand those charges, ma'am?
Yep.
And then in Meg file 224950, you are charged with petty theft in the 2nd degree. That's punishable by that's punishable by up to 30 days in jail and or $500 in fines. Do you understand that charge?
Yep.
Right. I reviewed your application for court-appointed lawyer. Did you make less than $50,000 last year?
Yep.
I'll find that you qualify and I'll appoint the Public Defender's Office to represent you.
Needs private counsel.
Oh, I'm sorry, you told me that, yes. I will appoint Sam Alvine to represent you. Will enter a not guilty plea on your behalf and schedule you for a 45-day preliminary hearing and a pretrial conference and jury trial date. Anything else from the state?
No, Your Honor.
All right, this will be a PR bond on conditions of good behavior. Stay in contact with your lawyer, make all court appearances, and no drugs without a valid prescription. And we'll get you those court dates, ma'am. With that, we'll be in recess and you'll be released later today. Thank you.
Thank you.
All right. Emmanuel
We escalate soon, guys. Don't worry. We escalate.
Miller. This is State of South Dakota versus Emmanuel Miller. We have court file 25-9296. Sir, were you present when I advised you of your rights?
Yes.
And did you understand those rights?
Yes, sir.
You were here today charging counts 1 and 2 with aggravated assault. Count 1 specifically alleges that you did attempt to cause serious bodily injury or cause such injury to Danielle Berg under circumstances manifesting extreme indifference to the value of human life. And count 2, you're charged with aggravated assault. It alleges that you did assault Danielle Berg with intent to commit bodily injury, which resulted in serious bodily injury. That's a Class 3 felony, and it carries a maximum potential penalty of up to 15 years in prison and or $30,000 in fines on each of those charges. Do you understand those charges here today, sir?
Yes, Your Honor.
Right. I've reviewed your application for court-appointed lawyer. I'll find that you qualify and I'll appoint the Office of the Public Advocate to represent you.
We would accept that appointment, waive further reading and advising.
Thank you. State's position on bond.
State is requesting $5,000 cash and no contact with the victim, Daniel Berg. The defendant's actions show that he is a danger. Here, he was in an altercation with this victim. The defendant punched the victim in the face. The victim then fell to the ground, and the defendant proceeded to stomp the victim's head into the concrete. The victim was unconscious and had to be transported to the hospital. He had to have surgery to repair his orbital socket. That was broken. Based on these facts, state police bond is appropriate.
Ms. Hofer.
Thank you. I would ask that you consider a PR bond.
Oh, shut up. Shut up. How dare you even say those words? $5,000 bond? Are you nuts? Okay, that's at least 30,000 minimum, right? 5,000?
Given Mr. Miller's lack of history, the information I have indicates no prior felony convictions, no prior crimes of violence in terms of misdemeanors. He has ties to the community. He has been here in the Sioux Falls area for 6 years, has a local address, indicates that he just got out of treatment. This happened back in August. I don't believe there's been any further incidents or indication that he's attempted to contact the alleged victim. Witnesses indicate that the fight started as a mutual combat between the alleged victim and the person who's alleged to be Mr. Miller. But he really has no history whatsoever, and nothing has happened since August, so I'd ask for a PR bond.
In this case, the defendant doesn't have any history. He presents a PSA score of a 3.2. He otherwise has good community ties, so I'm not worried about him being a flight risk. I do have concerns about his potential danger to the community, given the allegations here, the seriousness and the potential strength of the state's case. So I do think some bond is appropriate. I'm going to order a $3,000 cash-only bond on conditions of good behavior. Stay in contact with your lawyer, make all court appearances.
Get the hell out of here. $3,000. You gotta be kidding me. Wait, what? Look, I see a lot of court, and this one is shocking.
And no contact with Daniel Berg. No contact means no in-person contact, no telephone calls, no text messages, no messages through a third party whatsoever. I'll enter a not guilty plea and schedule you for a 15-day preliminary hearing, sir. Thank you.
Yes, Your Honor.
Hanwiapa Red Willow. This is State of South Dakota versus Hanwiapa Red Willow. It is court file 2687. Ma'am, were you present when I advised you of your rights?
Yeah, I was,
And did you understand those rights?
present, like, in the courtroom.
I'm sorry, what?
In the courtroom?
Yes.
Yes.
All right. You're here today charged in count 1 with possession of marijuana. It's a class 1 misdemeanor. It carries a maximum potential penalty of up to a year in jail and or $2,000 in fines. In count 2, you're charged with possession of drug paraphernalia. It's a class 2 misdemeanor. Carries a maximum potential penalty of 30 days in jail and or $500 in fines. Do you understand those charges?
Yes.
I've reviewed your application for a court-appointed lawyer. I'll find that you qualify and I'll appoint the Office of the Public Advocate to represent you.
We'd accept that appointment, waive further reading and advising.
Thank you. State's position on bond.
No objection to PR.
This will be a PR bond on conditions of good behavior. Stay in contact with your lawyer, make all court appearances, and no drugs without a valid prescription. I'll enter a not guilty plea on your behalf and schedule you for a pretrial conference and jury trial date. Thank you.
Okay, thank you.
Does she have anything pending, Julie, that we could pass it?
Not that I were, so you know.
Thank you. Matthew Rost? This is State of South Dakota versus Matthew Rost. It is court file 2693. Sir, were you present when I advised you of your rights?
Your Honor, yes, Your Honor.
And did you understand those rights?
Your Honor, yeah, I did. Yes, I did.
You are here today charged with one count of possession of a controlled drug or substance in Schedule 1 or 2, the named drug being methamphetamine. It's a Class 5 felony and it carries a maximum potential penalty of up to 5 years in prison and or $10,000 in fines. Do you understand those charges, sir?
Your Honor, yes, I do.
Right, I've reviewed your application for court-appointed lawyer. I'll find that you qualify and I'll appoint the Office of the Public Advocate to represent you.
We'd accept that appointment, wait for the reading and advising.
Thank you. State's position on bond.
No objection, no PR, Your Honor.
So this will be a PR bond on conditions of good behavior. Stay in contact with your lawyer, make all court appearances, and no drugs without a valid prescription. I'll enter a not guilty plea on your behalf and schedule you for a 45-day preliminary hearing. Thank you.
And then Alexia Hall and Virginia McDougal, I'm
They
not
did-
sure why.
They
are
didn't
not
come
coming.
over. They
Yeah.
refused.
Okay,
They're tomorrow, passed to tomorrow.
all right, thank you.
All right, Jessica Steele. Sandra, did you go back and speak with the paralegal?
Yes, I did, Judge.
Do you want to would you do me a favor and go back and ask for the application so we can get you out of here?
Oh, okay.
Oh, wait a minute, is Ruiz Daniel Ramirez one of them?
Jose, this,
Okay,
Maqueda.
we need the other one's application, then I
Another
don't,
one is Jordy.
okay. This is State of South Dakota versus Jessica Steele. We have court file POA 25-18332. Ma'am, were you present when I advised you of your rights?
Yes,
And did you understand those rights?
yes,
You're here today charged with having alcohol in a city park. It's a punishable by fine only as written on the ticket. Do you understand that charge?
yes.
Right, how do you wish to plead, guilty or not guilty?
Guilty.
You understand that by pleading guilty, you're giving up some rights, which includes the right to a trial, the right to confront and cross-examine any witnesses at that trial, and the right against self-incrimination. Do you understand that?
Yes,
So to the charge of having alcohol in a city park, how do you officially plead, guilty or not guilty?
guilty.
Has anybody forced you, threatened you, or promised you anything in order for you to plead guilty?
No,
Right, and were you here in Heritage Park on September 25th of 2025? You can shrug.
yes,
Right, and at that time, did you have alcohol in the city park on you?
yes,
All right, I'll find you factual basis exists for the plea and I'll find you guilty. The ticket was written for 107.50. You've been in custody since yesterday, is that correct?
no, for like a month now. I got sentenced on my other one already.
Okay, well, this was a warrant, so it was served, so I'm gonna give you credit for 1 day
Okay,
and we'll zero out your fines.
okay.
Thank you. Talia Guru. This is State of South Dakota versus Talia Guru. It's court file 25-9510. Ma'am, were you present when I advised you of your rights?
Yes, sir.
And did you understand those rights?
Yes, sir.
You are here today charged in count 1 with identity theft. It's a class 6 felony and it carries a maximum potential penalty of up to 2 years in prison and or $4,000 in fines. And count 2 and 3, you're charged with petty theft in the first degree. That's a class 1 misdemeanor and it carries a maximum potential penalty of up to a year in jail and or $2,000 in fines on each. Do you understand those charges?
Yes, sir.
I've reviewed your application for a court-appointed lawyer. Did you make less than $50,000 last year?
Yes.
Finally, you qualify and I'll appoint the Public Defender's Office to represent you.
Accept appointment, waive reading and advising.
Thank you. State's position on bond.
No objection, no PR, Your Honor.
This will be a PR bond on conditions of good behavior. Stay in contact with your lawyer, make all court appearances. I'll enter a not guilty plea on your behalf and schedule you for a 45-day preliminary hearing, ma'am.
Okay,
With that, we'll be in recess. Thank you.
thank you.
And then Yorby Jesus Denal Gode.
Jorby. Cancel o Jancel? Jancel. Godoy. Okay.
Why am I not finding him on the docket?
Ahora hacemos para acá porque ahí no.
There we go. Yes, Yancel Gode. All right, this is State of South Dakota versus Yorby Yancel Godoy.
Jancel Godoy.
It is Court File 2690.
2690 el archivo.
The defendant appears here today with a Spanish
Firmado por aquí
interpreter.
El intérprete de español.
Sir, were you present when I advised you of your rights?
Cuando yo di a saber los derechos. Yes.
And did you understand those
¿Y
rights?
usted los entendió? Yes.
You were here today charged with altering or forging a vehicle registration.
Dado fraudulentamente una registración de un vehículo.
It's a Class 6 felony,
Un delito mayor, felonía de clase 6.
and it carries a maximum potential
Era un
penalty
castigo máximo de
of up to 2 years in prison and or
años en prisión.
$4,000 in fines.
$4,000 de multa.
Do you understand that charge you are here on
¿El
today,
cargo,
sir?
señor? I do.
Right. I've reviewed your application for
He
a court-appointed
revisado
lawyer.
su solicitud para un abogado designado.
I'll find that you qualify,
Encuentro que sí usted califica.
and I'll appoint the public defender's
Voy a
office to
asignar a la
represent
Oficina de
you.
Defensores Públicos para que lo represente.
Accept appointment, waive reading and advising.
Renunciamos a la lectura y consejería.
State's position on bond.
¿Qué tiene que decir la Fiscalía en cuanto a una fianza?
No objection to PR, Your Honor.
This will be a
Hay
PR
opción
bond
que le den una fianza PR. La
on
fianza
conditions
PR
of good behavior. Stay in contact with your lawyer, make all court appearances.
solamente que usted tiene un compromiso de hacer todas sus
Will enter a
comparecencias,
not guilty plea on your behalf
mantener contacto con su
and
abogado.
schedule you for a 45-day preliminary hearing.
Usted está sujeto ahora a tener una audiencia preliminar en 45 días.
And we'll be in recess on that matter. Thank you, sir.
Estamos en receso en este asunto. Gracias, señor.
Thank you. And then Jose Vacadano Ramirez.
Oh, tome, Jorvi.
This is State of South Dakota versus
South Dakota.
Jose Vacadano Ramirez.
Ciudadano Ramírez,
It is Court File 2697.
2697, número de archivo.
The defendant appears here today with a Spanish interpreter.
La intérprete de español.
Sir, were you present when I
Señor, ¿usted
advised you of your
presente
rights?
cuando yo aconsejé los derechos? Yes.
And did you understand those
¿Usted los
rights?
entendió los derechos? Yes.
You were here today charging counts 1 and 2 with domestic abuse, simple assault.
1 y 2 de abuso, de agresión simple.
The state seeking to prove you guilty of one simple assault
La fiscalía nomás lo.
under 2 different subsections of the simple assault statute.
Agresión simple bajo un estatuto va a ser un solo cargo, aunque ahora se mencionan 2.
So this means if you're convicted of counts 1 and 2,
Usted puede ser condenado bien.
you're only convicted of one simple assault
Pero es una sola agresión,
and subject to one potential penalty.
sujeto solamente a un castigo.
In count 1, it alleges a crime of simple assault
Se le dice que usted cometió el delito de
and that you did attempt to cause bodily injury to another person
daños corporales a la
while
persona.
having the actual ability to cause that injury, so
Sin
attempted.
haberle causado, solamente fue un atentado.
Count 2 alleges a crime of simple assault
Dice agresión simple.
that you did intentionally cause bodily injury to another
realmente
person,
causó daños personales.
and that injury not being a serious bodily injury.
Ese daño corporal no fue tan serio.
And in count 3, you're charged with intentional damage to
Se
property.
le acusa por daños a propiedad intencionales.
The simple assault is a Class 1 misdemeanor.
Agresión simple es delito menor de clase 1.
It carries a maximum potential penalty of up to a year in jail and or $2,000 in fines.
Hasta un año en cárcel, $2,000 de multa.
Count 3 is a Class 2 misdemeanor.
A cargo 3, delito
Carries a maximum potential penalty of up to 30 days in jail
de cárcel,
and or $500 in fines.
de multa.
Do you understand those charges here today, sir?
¿De esos cargos, señor? Yes.
I've reviewed your application. I'll find that you qualify,
Solicitud para un abogado,
and I'll appoint the public defender's office to represent you.
Oficina de Defensores Públicos para que lo represente.
Accept appointment, waive
Okay.
reading and advising.
Thank you.
Anunciamos la
State-
lectura y consejería que
Spelling
tiene
the last name, Your Honor.
la Fiscalía.
We have it with a V, V-A-Q-U-E-D-A-N-O, D-A-N-O.
¿Se escribe su apellido? Sí. Ya. Que el fiscal está tratando de localizarlo.
It could be with a B.
Okay. Jose Luis Vacando Ramirez.
Vacadano Ramirez,
Okay.
yes.
No objection to a PR requesting no
No hay
contact.
objeción de la Fiscalía que se le dé a usted una
Luis
fianza.
Cruz Vasquez.
This will be a PR bond
Que va a ser una fianza.
on conditions of good behavior.
Usted tiene que tener.
Stay in contact with your lawyer.
Tener en contacto con su
Make all
abogado,
court appearances,
hacer todas sus comparecencias.
and no contact with Ingrid Johanna Cruz Vasquez.
Joana Cruz Vázquez.
No contact means no in-person contact,
El contacto
no
significa
telephone
que
calls,
no puede contactar
no text messages, and no messages through a
nada
third
de
party
texto,
whatsoever.
nada de correo electrónico, nada de redes sociales.
If you violate that, you can be
Usted
charged
tiene
with a new
que
crime.
quebrantar esas reglas o lo van a acusar de otro delito a usted.
With that, we'll be in recess. You'll be scheduled for a pretrial conference and jury trial date and will enter a
Van a
not
dar
guilty
una
plea.
fecha a futuro para comparecencia en una audiencia de preconferencia y luego fecha de juicio.
Thank you.
papeles son
And if I didn't point Grissom to the Public Defender's Office, please share discovery. And Weldon will be appointed to the Public Defender's Office, please share discovery.
Do you hear the bailiff playing with his handcuffs? Knock it off, dude. Don't they know how stressful that sound is?
Thank you, Sandra.
Thank you.
Sean Good Buffalo. This is State of South Dakota versus Sean Good Buffalo. It's court file 2696. Sir, were you present when I advised you of your rights?
Yes, Your Honor.
And did you understand those rights?
Yes, Your Honor.
You were here today charged with one count of simple assault against a law enforcement officer. It specifically alleges that you did attempt to cause
No bond. No bond. Judge, listen to me. Say it with me. No bond. You hit a police officer or any emergency response, you get no bond. That should be it. Now the guy that it ends with a bang with is sitting to the right. Okay, it's over in this side, not the one way up in the corner.
bodily injury to Gina Stockland, who is a healthcare professional who is engaging in patient care and who had the actual ability to cause that injury. In this case, it's a Class 6 felony, and it carries a maximum potential penalty of up to 2 years in prison and or $4,000 in fines. Do you understand that charge, sir?
Yes, Your Honor.
I've reviewed your application for court-appointed lawyer. I'll find that you qualify and I'll appoint the Public Defender's Office to represent you.
Accept appointment, waive reading and advising.
Thank you. State's position on bond.
No objection to a PR.
This will be a PR bond on conditions of good behavior. Stay in contact with your lawyer and make all court appearances. We'll enter a not guilty plea on your behalf and schedule you for a 45-day
Judge, what do you mean a PR bond?
preliminary hearing, sir.
Thank you.
Thank you.
I have a question.
Go ahead.
I'm on a 48-hour hold from 24/7,
Okay.
and I think it runs out tomorrow. Do I still get out on that bond?
So if you only are being held, I only have control over what you're appearing on here today. So if something else is holding you, you'll be released when that's done.
Okay,
So if you have a 48-hour hold and that ends tomorrow, you'll be released tomorrow.
thank you.
Yep. Guillermo Segala. This is State of South Dakota versus Guillermo Segala. It's court file 2699. Sir, were you present when I advised you of your rights?
Yes, sir.
And did you understand those rights?
Yes, sir.
You were here today charged in count 1 with child abuse. It specifically alleges that you did abuse, expose, torture, torment, or cruelly punish a minor whose initials are RAP with a date of birth of January 16th of 2011. It's a Class 4 felony, and it carries a maximum potential penalty of up to 10 years in prison and or $20,000 in fines. In count 2, you're charged with simple assault domestic. It alleges that you did attempt to cause bodily injury to another person and had the actual ability to cause that injury, so attempted. It's a Class 1 misdemeanor. In count 2, you're charged with intentionally causing contact with bodily fluids or human waste. Well, it's also referred to as sliming. It's also a Class 1 misdemeanor. Each of those carry maximum potential penalties of up to a year in jail and or $2,000 in fines. In count 4, you're charged with purchasing or possession of alcohol while under the age of 21. And in count 5, you're charged with possession of tobacco while under the age of 21. Each of those are Class 2 misdemeanors, and they carry maximum potential penalties of up to 30 days in jail and or $500 in fines. Do you understand those charges, sir?
Yes, sir.
Right, I've reviewed your application for court-appointed lawyer. I'll find that you qualify and I'll appoint the Public Defender's Office to represent you. Do you accept appointment, waive further advising and reading?
Sorry, yes, I do.
Thank you.
I got confused.
State's position on bond.
State is requesting $2,500 cash and no contact with a minor, initials RAP, date of birth January 16th, 2011, Sarah Ramos, and a no alcohol condition. Law enforcement was called because the defendant assaulted his mother and 14-year-old sister. He punched both of them and then spit on his mother. The defendant's mother explained that the defendant spit on her and it currently has a contagious bacterial infection. The defendant had been consuming alcohol prior to the assault, and the defendant's mother had obvious injury to her face that was caused by the defendant. Defendant's history shows a pending case with charges of simple assault on a law enforcement officer, obstructing, resisting, and underage consumption. Because the defendant's conduct shows he is a danger, State believes $2,500 cash bond is needed. Thank you.
Thank you. Ms. Capilupo?
Judge would ask the court for a PR bond. He does have an alternative place to stay while the court does order a no contact. He indicates that he would be able to abide by that. I do believe the safety of the individuals could be protected with that no contact here. He indicates that he's been in the area all his lives. I don't believe there's any failure to appear, anything indicating that there is a flight risk or any things associated with that. I believe that simple assault on law enforcement case that was referenced by the state, there's actually a remand that's filed in that matter, indicating that there's no felony that's going to be there. So would have the court take that into account as well. I don't believe there's any other violent allegations on his history outside of that. The report that I got, it was 3 sentences, so I don't have the information I think that the state's referencing. Nothing in what I was given indicates that there was any injuries, any blood, anything involving any of that. There was one comment indicating there was an infectious disease, nothing to support that. Given that he's here today, I don't think that that's probably true. I would have.
That's his hair. It's just his hair. They are standing behind a piece of glass, but that is just his hair.
The court take that into account. PSA score extremely low at 2.4. Nothing else in the report that I was given indicates that there was any injuries, anything along those lines. Given the young age, would have the court consider PR bond.
Mr. Segala presents to the court with a PSA score of a 2.4, which means he has a low risk of flight, a moderate risk to reoffend. It's evidenced by the fact that he's a pending simple assault charge. That might be set for a remand, probably safe bet, maybe a misdemeanor simple assault is what the plan is. I'm not necessarily sure. Nevertheless, there's a pending assault charge. Now we're back here on new assault charges, one of which is a felony charge involving a minor. So I do think he does present as some danger to the victim and to the community as a result of the multiple assaults pending. So I do think bond is appropriate at $2,500 cash on conditions of good behavior. Stay in contact with your lawyer, make all court appearances. No contact with the minor RAP, who has a date of birth of January 16th of 2011, and Sarah Ramos, and no alcohol while this case is pending, sir. I have signed an order for personal belongings, and that'll allow you to go over to the law enforcement center if you bond out and wait there for an escort and go over to that residence and obtain some of your things. With that, we'll enter a not guilty plea and schedule you for a 15-day preliminary hearing. Thank you, sir.
Judge, on, I think it's Elena Grissom, next Walter's appointed. I cannot argue bond on that.
You're not going to argue bond?
No, we have a victim on that.
Ms. Grissom?
Yep.
Ms. Grissom, come on up. This is State of South Dakota versus Elena Grissom. It's court file 2688 and 2689. Ma'am, were you present when I advised you of your rights?
Yes.
And did you understand those rights?
Yes.
In court file 2688, you are charged in count 1 with possession of a controlled drug or substance in Schedule 1 or 2, the name drug being methamphetamine. It's a Class 5 felony, and it carries a maximum potential penalty of up to 5 years in prison and or $10,000 in fines. In count 2, you're charged with possession of drug paraphernalia. It's a Class 2 misdemeanor. It carries a maximum potential penalty of up to 30 days in jail and or $500 in fines. Do you understand those charges?
Yes.
And then we have court file 2689. In that file, ma'am, you're charged with 1 count of aggravated assault. It specifically alleges that you did, by physical menace with a deadly weapon, a machete, put Jolene Thompson in fear of imminent serious bodily harm. It's a Class 3 felony, and it carries a maximum potential penalty of up to 15 years in prison and or $30,000 in fines. Do you understand that charge?
Yes.
I'm sorry, I know you're emotional, but I couldn't hear you.
Yes.
Thank you. I reviewed your application for court-appointed lawyer, and I'll appoint Max Walter to represent you. We'll enter a not guilty plea on your behalf. So here's the situation. Max Walter is obviously not here, able to assist you with your bond argument. So you have 2 options. We can either contact Max, and hopefully he can make it back here tomorrow and reschedule you for a bond hearing tomorrow in front of me. Or you can address bond yourself. Obviously, you don't have the assistance of a lawyer. You haven't been able to contact them. Nobody's reviewed reports. But those are your 2 options here today. Obviously, if you were to address bond yourself, I wouldn't want to hear anything about the facts or details from your case, because you have the right to remain silent, and I don't want you to make any admissions or confessions here today on the record. So knowing those are your 2 options, how do you want to handle it?
I would like to do it
I would like to appoint myself.
All right, state's request on bond.
State is requesting 5,000 cash and a no contact with Jolene Thompson on the ag assault PR on the PCS. Oh, sorry for the argument. Defendant is out on bond in 2 separate felony drug cases here in Minnehaha County, so she is supposed to be on her best behavior. She also has a warrant out in Lincoln County for burglary and grand theft. Here, she was moving out of the basement of a residence. She could not find her speaker. She thought the victim, who lives upstairs, had stolen it. When she confronted the victim and didn't get the answer she wanted, she came at her with a machete and threatened to, quote, cut her up, end quote. The defendant's boyfriend stopped the defendant, but not before the victim was afraid for her life. Based on those facts, state police bond is warranted.
All right, Ms. Grissom, what do you want me to know? I want to hear about your ties to the community and why you're not at risk of flight, mostly.
I'm not at risk of flight because I'm supposed to be going to treatment in 2 days on the 8th by 2 p.m. at Lewis and Clark.
Where are you going to treatment?
Lewis and Clark in Yankton. I'm supposed to be there before 2 o'clock. I also have a daughter that is in the same city as Sioux Falls. I'm also pregnant as well. I don't have any violent past. There was an aggravated with a deadly weapon before, but I didn't get charged with it. It was dismissed. I don't know what else to say.
Thank you, ma'am.
I'm sorry.
One moment while I look at some things. Well, so in this case, the defendant appears to the court with a PSA score of a 2-4. The issue is that she has 2 pending controlled substance cases. She has warrants out for burglary and grand theft, and now we are here on an aggravated assault charge. Not only is the alleged allegation here violent in nature, but she's alleged to have done it while out on bail. I do think that's particularly aggravated. So in this case, I do think that she does present as some danger to the community. I don't think she's a flight risk. So I do think $5,000 cash bond is appropriate.
What? No.
Conditions of good behavior: stay in contact with your lawyer, make all court appearances, no contact with Jolene Thompson, and no weapons while this case is pending, and no drugs without a valid prescription.
I don't have a violent past or drugs in my past. I've never been charged with anything. And this is my first time really getting in trouble. I haven't been sentenced.
Ma'am, you have
yet.
2 controlled substance cases pending.
Yeah, they're pending. I still
That's
haven't
what I
gotten charged
said.
yet.
That's what I said.
Why
So we're-
$5,000?
ma'am, we're done. I've decided, I've listened to your case. I think I've explained that for those reasons, I think this bond is appropriate. You yelling at me and becoming emotional is not helping your
I didn't mean to
case.
yell at you. I don't mean to yell at you.
Not helping your case. And I want to note that bond was argued and that she has a lawyer isn't necessarily a change of circumstances to review it. Yep, and then a PR bond on the controlled substance case, conditions of good behavior, stay in contact with your lawyer, make all court appearances, and no drugs without a valid prescription.
I didn't believe her at first when she said she was pregnant, but I think she is.
Thank you.
The way she moved.
Trevor Quincy. Oh,
Yeah.
I didn't PR him though, right? Segala? I didn't PR Segala. No. Shred that one. One moment, Mr. Quincy.
How you feeling?
Thank you. Right, this is State of South Dakota versus Trevor Quincy. We have court file 2694. Sir, were you present when I advised you of your rights?
I was.
And did you understand those rights?
I do.
You were here today charging counts 1, 2, and 3 with domestic abuse, simple assault. Count 1 specifically alleges that you committed the crime of domestic abuse, simple assault, and that you did attempt to cause bodily injury to another person while having the actual ability to cause that injury so attempted. Count 2 alleges a crime of domestic abuse, simple assault that you did recklessly cause bodily injury. Count 3 alleges a crime of domestic abuse, simple assault that you did by physical menace or credible threat, put another person in fear of imminent bodily harm with or without the actual ability to cause that harm. Domestic abuse, simple assault is a class 1 misdemeanor. In count 4, you're charged with interference with emergency communications. It's also a class 1 misdemeanor. They all carry a maximum potential penalty of up to a year in jail and are $2,000 in fines. Do you understand those charges, sir?
Yeah, I understand I'm not guilty of them.
Right. I've reviewed your application for a court-appointed lawyer. I'll find that you qualify and I'll appoint the public defender's office to represent you.
Accept appointment, waive reading and advising.
Thank you. State's position on bond.
No objection to a PR, no contact with victim April Jackson.
This will be a PR bond on conditions of good behavior. Stay in contact with your lawyer, make all court appearances, and no contact with April Jackson. No contact means no in-person contact, no telephone calls or text messages, no messages through a third party whatsoever.
Yes, sir.
Do you understand those conditions, sir?
Yeah.
All right, we'll enter a not guilty plea and schedule you for a pretrial conference and jury trial date. And then I have received this order for personal belongings.
Yes, please.
This will allow you to take a copy of this order and go over
Sheriff's office.
to the law enforcement center and wait there for a law enforcement escort to escort you over to that residence to get some of your things.
Thank you.
Right, with that, we'll be in recess. Thank you.
Thank you very much.
Alan Weldon. This is State of South Dakota versus Alan Weldon. It's court file 2695. Sir, were you present when I advised you of your rights?
Yes, sir.
And did you understand those rights?
Yes.
You are here today charged in count 1 with
I was wrong. We are not waiting for that guy behind the bar. We've arrived. We've arrived at the bang.
simple assault against a law enforcement officer. It alleges that you did attempt to cause bodily injury to a law enforcement officer who was engaged in the performance of his or her duties and had the actual ability to cause that injury. It's a class 6 felony and it carries a maximum potential penalty of up to 2 years in prison and or $4,000 in fines. In count 2, you're charged with intentionally causing contact with bodily fluids or human waste, what we call sliming. It's a class 1 misdemeanor. In count 3, you're charged with criminal trespass. That's a class 1 misdemeanor. And in count 4, you're charged with obstructing a law enforcement officer. That's also a class 1 misdemeanor. All of those carry maximum potential penalties, counts 2 through 4, of a year in jail and or $2,000 in fines. Do you understand those charges?
Yes, sir.
All right. I've reviewed your application for a court-appointed lawyer. I'll find that you qualify and I'll appoint the public defender's office to represent you.
Accept appointment, waive reading and advising.
Thank you. State's position on bond.
State is requesting $10,000 cash. The defendant is on parole and is facing up to life in prison based on his criminal history. He has at least 8 prior felony convictions, including drugs, failure to appear, and felony simple assault. He has 6 simple assault convictions in the last 10 years, and many others that were reduced to disorderly conduct or dismissed. 2 of his simple assault convictions were reduced from aggravated assault. He has a pending aggravated assault. Here he was arrested for trespass after he kept coming back to his ex-girlfriend's place after police told him to leave. When he wasn't cooperative, he was arrested, ended up spitting in the face of an officer and also bit his finger, drawing blood. The defendant does have HIV, so the officer had to get his blood drawn. That is currently being tested, and the officer is currently on 4 different medications as a preventative measure. Based on the facts here and the defendant's history, State Police $10,000 cash is warranted.
Ms. Capilupo.
Judge, I'd ask the court to consider a PR or a lower bond.
Oh God, I can't take it. $10,000? PR bond? Are you freaking nuts? Can we please speak with reality?
It does have a local address, phone number, has a child, an 8-year-old that he is supporting currently, has been in the area for 10 years, is on parole supervision. I do see there is a parole hold at this time. It's unclear as to what parole's plans are. Parole actually was on scene here. Parole did PBT him. It does appear that there was an intoxication here. He indicates he did have his parole officer come and speak to him yesterday, indicates as well parole did not reveal what their plans are for him, but there is that parole hold right now. He is on 24/7 for a separate file, so there is that as well. Is employed at Slim Chickens, does have family in the area, ties to the community, does understand he needs to keep in touch with us and parole and make his court dates.
So the defendant appears today, oops, one moment, I'm sorry. Defendant appears today with a PSA score of a 5.6. He's on parole. He has a pending aggravated assault charge that he's out on bond for. The allegations here are violent in nature. So I do think based off of those circumstances, he does present as a danger to the community. And I do think bond is appropriate at $10,000 cash on conditions of good behavior. Stay in contact with your lawyer, make all court appearances. I will enter a not guilty plea on your behalf and schedule you for a 15-day preliminary hearing. Were there any other conditions the state was asking for?
No, Your Honor.
All right, thank you. That will be in recess on that matter. Thank you,
He got a gift. He got a gift and he's unhappy.
sir. Who do I have left here?
Last name Pyne.
Thank you.
Hey,
Mr. Pine? This is State of South Dakota versus, is it Bay Pine? How do you say your name, sir?
however you want to say it, I don't really care.
All right, it is court file 2691. Sir, were you present when I advised you of your rights?
Yeah,
And did you understand those rights?
yeah,
I couldn't hear you, I'm sorry.
yep.
Thank you. You are here today charged with one count of criminal trespass. It's a class 1 misdemeanor. It carries a maximum potential penalty of up to a year in jail and or $2,000 in fines. Do you understand that charge, sir?
Yep.
I'm really sorry, there's a fan out here and it's going and I can't hear you. Can you say that a little louder?
Yep.
Right. And how do you plan on proceeding here today, to plead guilty or not guilty?
Guilty.
State have a position if he pleads guilty.
Suspended open on the sole count.
The state's indicated if you plead guilty, it would be a suspended jail sentence. How much would be up to me? How much in fines and court costs you pay would be up to me as well. The conditions I place on your suspended sentence would also be up to me. There are going to be conditions of no like offenses for a year. Do you understand what would happen if you pled guilty here today, sir?
Yep.
And knowing that, do you still wish to plead guilty?
Yep.
You also wish to understand that if you qualified, I would appoint a lawyer to represent you. Do you still wish to plead guilty without first consulting with a lawyer here today?
Yep.
Right, so you also understand that by pleading guilty, you're giving up the rights that I advised you of, which includes the right to a trial, the right to confront and cross-examine any witnesses at that trial, and the right against self-incrimination. Do you understand that? I need a verbal response for the record. And I'm sorry, I didn't hear one.
Yep.
Thank you. So to the charge of criminal trespass, how do you plead? Guilty or not guilty?
I already told you guilty.
Thank you. Has anybody forced you, promised you anything in order for you to plead guilty here today?
No.
Factual basis from the state.
On January 5th, 2026, law enforcement were dispatched to 120 East 11th Street at 1903, or at 7:03 p.m. for a disorderly subject. Reporting party stated defendant was refusing to leave a bus stop, was carrying a metal rod, and was possibly intoxicated. Law enforcement arrived at 7:05, saw other officers already talking to the subject, who identified himself as this defendant.
I was not intoxicated.
Law enforcement asked the man if he would leave, as he'd been instructed. He said he would resist if law enforcement attempted to arrest him. The defendant was arrested. All those events occurred in Minnehaha County.
Sir, do you agree that you were at the bus stop and told to leave and failed to leave when asked?
I was not intoxicated. I don't know what.
Yep, we'll note that for the record. That's not required for the trespass charge, but do you otherwise agree with that?
I'm pleading guilty, ain't I?
Yep, in order for you to plead guilty, there need to be facts on the record that you agree with that establish a
Guilty. I
crime
don't
was
care
committed.
about the facts. I'm just pleading guilty. So
Well, I need you to say yes or no if you agree with those facts or not.
I'm not gonna agree with the facts, but I am
All
gonna
right,
plead
then we'll
guilty.
enter a not guilty plea here today, and we'll schedule you for a pretrial conference. and
I don't know
jury
what you're
trial date.
talking about. I just plead guilty. How you gonna?
Because there's not, you didn't establish a factual basis, and I'm not here to force it out of you. So if you disagree with the facts, that's fine. We can come back to court and talk about it at a later
I don't
date.
wanna come back to court. I wanna settle this right now. I already told you. I
Well,
plead
do you
guilty.
agree that you failed to leave that bus stop when asked?
And I'm not gonna go into that. I just plead guilty already.
Yep, and I'm not going to accept a guilty plea. So it'll be a not guilty plea here today. We'll schedule you for a pretrial conference and jury trial date. State okay with a PR bond?
We are, Your Honor.
This will be a PR bond on conditions of good behavior. Stay in contact with your lawyer and make all court appearances. Thank you, sir.
Kristen, thank you so much. That was definitely worth it. You did great. Okay. This next one This next one, okay. This was supposed to be the final hearing in I always forget the words to these cases. Reunification hearing. So the mother has lost custody of her child. So she had to get a job. She had to, get an apartment, somewhere to live, blah, 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 all the stuff that you're supposed to do. The mother says that she does not do drugs. She does not drink. But she did have one drop that was positive for alcohol. Okay? So this was supposed to be the final hearing to determine whether she gets her child back or not. And the judge was supposed to make a decision today. He does not. He gives her more time because she did in fact get a job. But I think it's prostitution. And she did in fact get an apartment. But I think it's with her pimp. Tiffany is the name of the person that she works with. And I think the father or the guardian ad litem is unhappy with her job. Now I think she does also work as a stripper. And I think that part is the part that they don't like. But it's a job. I mean, it is a job. But that's what we're going to go to next, because that's what you guys deserve today. I just know that it's not going to be, I'm going to have to resize it real quick.
Engaging in prostitution.
And then I did turn the volume down for that last case. So I am going to go ahead and turn it back up again, because it sounds like this one is much quieter. I got to move us back to where we belong. There we go.
Engaging in prostitution came about.
Yes.
All right, and the I guess the drug screens that she provided were positive, correct?
In October, yes.
All right, and give me 1 minute. And so, have you talked to Justice about those drug screens?
Yes, I did.
And since what was her response to those drug screens being positive?
She said that she's never done drugs.
Okay.
She wanted to retest. I checked with my supervisor, and this was a hair follicle test, which we normally do every 3 months with a parent. And the answer that I relayed to Justice was that if she wanted to retest, we would not be paying for the test or authorizing the test, but she could go test on her own if she wished.
Now, has she done a subsequent drug screen for us?
I sent her to do another hair follicle in late December, given that court was coming up. So it was 2 months from the previous hair follicle. So it was a little early, but I went ahead and sent her to do a hair follicle and a UA. And both of those were negative.
Okay. But the one in October was positive for cocaine and methamphetamines, correct?
The hair follicle was, yes.
Now,
sorry. I thought it was alcohol only. It looks like it was drugs.
This may speed this thing along. Ms. Wildman, I'm looking at the report sent for this hearing today, and the recommendations are that an extension be granted and that the department continues temporary managing conservator. So That having been said, I don't see any way that I'm not going to grant the extension.
Well, and Judge, I'd say that the department's that's no longer the recommendation.
Well, I would say that that's a little too late to change your position. So no one obviously needed to be prepared for a final hearing today when the department themselves are asking for an extension. So you go ahead and make your record if you want, but obviously I would assume Ms. Archie would claim surprise. She read the report and the extension was recommended by the department. So anybody want to put on any more testimony about an extension? Go ahead and do it now.
And Your Honor, I think that's pretty much the concerns the department had as to why we wouldn't want to do an extension. And then we do have a couple witnesses that we will need to call to do if we would do a permanency hearing, which we would request to do because there are some additional concerns that have come up in preparation for the final that the court needs to address, and we may need to have additional services ordered if we're going to do an extension.
Okay. Let me back into that. Do you have witnesses that were here for a final that we're not going to have that could be released?
Yes, let me find my list. Hang on.
Okay.
Your Honor, while she's looking at that,
housing and to maintain it for 6 months.
Okay. And do you have concerns about whether or not she's able to do that with Ms. Reese present?
I do have concerns.
What do you believe at this point returning Navasia to Ms. Johnson would be contrary to the child's health and well-being?
Yes.
What sort of continuing danger concerns does the department still have, if any?
Well, we have concerns about the substance use that we heard about. We have concerns about the lack of stable employment. We have concerns about whether she's been forthcoming about the types of employment that she has. We have concerns about the escorting that she was doing before. And we've become aware that, and I did an employment verification on Cassidy's, that is a adult entertainment venue in Amarillo, that she has a contractor employment relationship with them, and she has not disclosed that at all. So we're concerned about the environment and having a child and working in that sort of environment.
Specifically regarding Cassidy's, did you have a conversation with her about their text message regarding, I guess, stripping equipment? In regards to a text message from Miss Reese that she sent you?
Well, yes, Tiffany, let me say, Justice sent me a text screenshot of a conversation with her and Tiffany, in which Tiffany referred to her stripping, yes.
Okay, but what is stripping equipment? What equipment does she need? Okay, dancing, maybe you need a pole, right? But what exactly is stripping equipment? Is it her, like, costumes? Maybe? I don't know.
And what did Justice say in response to that regarding that employment?
She did not disagree with it. She did not deny it to me.
Okay.
She simply said that she gave me the screenshot as a way of saying, this is why I don't want Tiffany involved in my case. And there was a lot of foul language that was in Tiffany's text.
And was that prior to or after you had then, or I guess, was that before or after you then were able to verify she was working at Cassidy's?
That was before. That exchange was in late October. It was around the time that that she was expressing to me that she wanted to relinquish the child. And then the verification of the employment at Cassidy's was in December.
Now, the
last time I tried to get stripping equipment at the stripping equipment store, the sales lady wouldn't sell me the one that I wanted. The one toy that I wanted, she said, no, that's a fire extinguisher?
The service plan that's been developed and the services that the department has helped Justice engage in, do you believe that those are reasonable efforts to reunify?
I do.
Do you believe that facilitating the ongoing visitation, including the in-person visit that you supervised, are reasonable efforts to reunify?
Yes.
And do you believe the department has made reasonable efforts to reunify Justice with Navajo?
Yes.
Are you recommending that TMC and placement continue at this time?
Yes.
And are there any other requests that the department has other than the ones we've already covered?
No.
I'll pass the witness, Judge.
All right, thank you. Tim, I think you testified to this. I was busy. Did you say that her drug tests in December were negative?
Yes, sir.
Did she have a hair and UA?
She did. The hair follicle was negative in December, and the hair follicle in October, which was 2 months prior to that, was positive for cocaine and meth.
But then in December, a UA was also negative?
Well, the UA was negative in both instances, October and December.
Do you know, has she ever been tested for alcohol?
I'm not absolutely sure.
Okay, so if we're going to send her for a
the
UA
previous
today,
caseworker might have done that.
well, my question is for you.
I would like her.
You want her tested on a UA today, including alcohol, correct?
Yes, Judge.
Okay, all right. Okay, Ms. Archer, any questions?
Yes, Judge. So Mr. Koval, you were talking about the counseling. Did Justice receive a discharge from Ms. Lawson?
She did.
And in that discharge, did Ms. Lawson state that she'd had 6 months of stable housing and employment?
Yes, Ms. Lawson did state that. And that was not accurate.
And as far as the domestic violence support group, did Justice know how many she had to do at the outset?
That would have been the previous caseworker. I'm not sure if the previous caseworker gave her a specific number.
And would you be open to Justice having more in-person visitation if the department can pay to get her to placement?
I'm not opposed to that. I don't know that placement needs to be supervising it. So there would be some logistics to work out, but it wouldn't stand in the way of mom seeing her child and the child seeing mom.
Perfect. And as far as Justice staying with Miss Reese, have you ever been to their apartment?
I have.
Okay, is it appropriate for a child?
The new apartment, I didn't go upstairs, and because of the hostility that was happening during that visit, we were only there for about 14 minutes and just right inside the den area. So I did not do a walkthrough. So I can't really answer as to whether it was appropriate or not.
I guess this is why I'm asking if your stance is that Justice needs to leave that apartment, because I know that you and Miss Tiffany Reese don't really mesh. I mean, is it fair to say a child wouldn't be okay there?
Can you rephrase? Because you kind of
Sure.
lost me.
That was very confusing. So you agree you have not seen the apartment?
Not completely. I haven't seen a bedroom where the child would be. I've only seen the living area just inside the door.
So you don't really know if the child, if returned to this facility, this apartment, would be unsafe?
Not in terms of the physical nature of the apartment. Our concern is more about the personal aspects of it, the who rather than the what.
As far as you know, Tiffany Reese has never hurt a child, though, correct?
I'm not aware of her hurting a child.
Does the department allow women to work at Cassidy's and still have children?
Judge, I'm gonna object to argumentative. I think he just stated that's not his chosen, or that's not ideal for his situation.
Well,
That's not ideal for his situation. Her working at a strip club is not ideal for what he thinks a mom should be allowed to do.
but he can answer that again if that's his, she asked if the department does not allow, so.
I mean, I'll be honest, I haven't had a case in which that type of employment has been involved. So.
You don't know what the department would do. Is that correct, Mr. Cole?
That's correct, Judge.
Okay, that's a good answer too.
Would you agree if Justice
No, it's
worked at
not.
Cassidy's but didn't drink alcohol or do drugs, that she could still parent safely?
Yes, I agree with that.
I can't answer that definitively because if she decided to take the child into that environment, rather than keep it separate, then that would be a cause of concern.
I don't think Cassidy's would allow that.
Well, they're not here to testify, so I don't know.
That would be an interesting hearing, maybe next time. I'll pass the witness, Judge.
How dare he? How dare he? I don't understand what's going on here. I feel like we're in 1950 right now.
Thank you. Ms. Wiggins?
I have no questions.
All right. Okay, Ms. Archer, I guess, all right. Ms. Archer, any witnesses?
Yes, I'd like to call my client. What's your relationship with Tiffany Reese?
She's more of like, since I don't have my mom in my life, she's more of like a mom to me, but we're not biologically related.
Pimp to her.
Would you say that she keeps you accountable as far as following rules?
Yes, ma'am.
Sometimes when you argue, is that what it's about?
Yes, ma'am.
Money.
Because sometimes I would like to put my 2 cents into things, and then we kind of head, but we always come back and talk about things.
Do you think that your child would be safe in the environment, in the apartment you're in now with you and Tiffany Reese?
Yes, ma'am, I would say that. Because before I got my case, she was around my daughter. She was coming to get my daughter after she got off work every day and would take her to go eat Chick-fil-A and everything.
So you trust her around your daughter?
Yes, ma'am, I do.
What's your situation with your lease? Are you on the lease?
That's basically what it is. With the occupant, they didn't put, like, when she first got it, she was the only one on there, but then she put me as a second, but I haven't talked to, what is it? What's the lease person? I don't know what they're called. But basically, what I sent over to you is what he gave us. That's what he put me down as the occupant. But I do pay half of the rent here.
Can you explain to the court and Mr. Coville about your pay stubs? Why don't you have pay stubs?
Because whenever I was working with her, it was like, how do you say it? Well, I was working with her and I was getting paid half of, she would give me half of what she got paid.
Okay.
So it was like a private Tiffany. It was a private corporation. So we got paid by the person that we were working for.
Okay. And then on the documentation you sent me today, what are you training to do?
I'm getting my CPR license.
And why are you doing that?
So that I can go back to home health.
And at that point, when you finish that, will you be getting pay stubs?
Yes, ma'am, I will.
So before that, you were getting cash, basically?
Yes, ma'am.
But you were employed?
Yes, ma'am.
Okay. Have you asked to visit your child in person?
Yes, ma'am, I have.
And is that something you would like to do more?
Yes, ma'am.
Is it pretty hard when you're doing it by Zoom?
Yes, ma'am, because she'll be moving around or she'll be eating, so she'll be distracted by things, plus the other kids running around in the house, so, she'll want to go play, so.
Because how old is she right now?
She's 1.
As far as the extra services that they're requesting, how many domestic violence classes did you think you would have to do?
Whenever I had what was her name? Was it Miss Amy? The one that I had before, Mr. Tim? She had requested that I do 10 domestic violence classes to be completed. And that's how many I had. I completed 11 in total.
Do you feel like you learned something from those?
This one I actually learned a lot. Because when the situation of what was brought up about what happened with the incident on that day whenever I was intoxicated, I ended up going to.
Yeah, you've answered the question.
That's okay. And you finished all your counseling sessions and got discharged, correct?
Yes, ma'am, and I added extra.
And so do you think it's necessary for the court to tack on 6 more like they're asking?
So I don't feel like I need them, but I will do them.
Okay, thank you, Justice. I'll pass the witness.
All right, Ms. Wyman, any questions for her briefly?
Yeah, I'll try to keep it brief, Judge. Ms. Johnson, why did you tell Ms. Lawson that you had consistent housing and employment for the last 6 months?
Because I was with Tiffany before the month of September. I had been with her.
Okay, and when did you tell Mr. Koval that?
When he had came, we had talked briefly, but I don't think he remembers me telling him because he had only came that one time to the apartments. I was there before he had came.
Okay, so you'd agree with him then that he came in September, right?
Yes, ma'am.
Okay, so September was roughly 3 months ago. So how long are you saying now that you've been with Miss Reese?
It would be a total of 4. I
Okay.
think so.
So not 6 months, right? Okay. And you agree with Mr. Koval that you guys have moved at least once since you've been living with Miss Reese, right?
Yes, ma'am.
Okay. And you haven't been employed by any one place for 6 months, correct?
No, ma'am.
Okay. So do you understand how that would be untruthful and cause concern for the rest of how truthful you were in the rest of your counseling?
Yes, ma'am.
All right. Now, why did you not inform the department of this incident that occurred with Mr. Williams in June?
Because I had talked to the cop, and what was said was I asked them if it was gonna affect my court case, and they was like, no, this is an emergency with you. It has nothing to do with your daughter.
Okay, but do you think that considering there were concerns about domestic violence at removal, it's something that the department would have needed to be made aware of?
No, ma'am. I didn't think to say anything about it.
So you don't think it would be important for the department to know that you were assaulted?
Okay, let's move on. We're running behind, Ms. Wyman.
Okay. And you don't believe that it would be important for the department to know that you were drinking underage?
They actually did know that. I don't know if the first caseworker had told him, but I did say I recreationally drink sometimes.
Okay, but not in June of 2025, right?
I don't think she informed him.
Okay, and again, you didn't inform anybody of the incident with Mr. Williams, right?
No.
I'll pass the witness, Judge.
Ms. Wiggins?
No questions.
All right. All right, Ms. Archer, did you have any other witnesses?
No, I have one follow-up.
She's a liar because she got assaulted and didn't tell them? I don't know. I mean, about the drugs, absolutely.
Question, Judge.
Okay. All right.
Justice, why did you and Tiffany Reese move from one apartment to the other?
To have a bigger space because it was a 1-bedroom at the time. So we got a 2-bedroom to have bigger space so that I can be able to put a bed in her room with me.
Thank you. No further questions.
All right. Any other witnesses, Ms. Archer?
No, Judge.
All right, Ms. Wiggins, recommendations?
Thank you, judges. Recommend that the child's placement be continued. And then I guess the department remain temporary managing conservator.
Okay. Can somebody tell me, Ms. Lawson, the counselor, what's her first name?
Melissa?
Melissa, thank you. All right, Ms. Johnson, unmute again, please. Do you have transportation to get to Care Express today for a UA test?
At what time were you want to do that?
You'll have to be there by 4 o'clock, no later.
Because she's not off work until 5.
Okay, all right. I'm going to put you in a breakout room with Mr. Koval here in a minute, and y'all can arrange how you can get there because I want you to drug test by 4 p.m. today.
Yes, sir.
If you don't have a ride, they'll get you there,
Good
I promise
choice,
you.
Judge. Good job.
Yes, sir.
Okay. All right then. As I've stated earlier, I have granted the department and the mother's motion to extend the case, even though the department didn't want me to today. I will continue the department as temporary managing conservator, continue the child's current placement. I'll order Ms. Johnson to undergo an OSAR and follow all recommendations. And I will order Ms. Lawson to UA drug screen by 4 p.m. today at Care Express, including test screening for alcohol consumption.
Judge,
As
you
far
said
as
Ms.
the-
Lawson.
I'm sorry, Ms. Johnson. As far as any additional counseling, I'll order Ms. Johnson to undergo any additional counseling only as recommended by Melissa Lawson. Okay, I will set a final in this case for May 4th, 2026. It will be by Zoom, just like today's hearing, so parties can ask their lawyers or anyone can go on the court's online docket a day or two before May 4th to see what time we'll have that hearing. All right, we'll be in recess on this case. I'll be back here very shortly to call another Randall County case. That's a compliance hearing on the Mason child. So we'll be in recess. Everybody have a good rest of your week.
You too,
Judge.
Thank you, Judge.
Engaging in prostitution.
So she did what they said. She got a job they don't approve of. She got an apartment. I don't know. She lives with Tiffany. So there's that. And Tiffany and the guardian ad litem, or the caseworker, I don't know what he is, hate each other. They hate each other. So, but just because he's mad at this other lady, she did what she was supposed to be doing. Now, she had to go get tested today. That I think should sell it. If she tests clean, then she did what they said. The child's won. So, I don't know.
Your Honor, this involves a burglary at 2 different locations here, or in Montgomery County.
We are going to finish the day in Georgia, except Georgia hasn't really streamed in like 2.5, 3 weeks. Not the whole entire state of Georgia. When I say Georgia, I mean the judges that you can only find here, only on court vibes, and maybe on court disorder if I'm feeling nice that day. So this is from a couple weeks ago. I miss my Georgia judges. Don't worry, no one ever chats there. That's not true. They say no sound, no sound, no sound, because the judges like to mute a lot, but they don't really chat. So we don't need to see that window. Nothing, no big bangs here. Just our lovely accents to finish out the stream.
The location, one was in count 1 as to Chris Snell on McCrae Street in Mount Vernon, Georgia, Montgomery County. Second location was at 511 South Fountain Street in Mount Vernon, location owned by Tanner Boyd. In those cases, Your Honor, came to the attention of Officer Macy Dean, who works not only with Mount Vernon PD, but also at the time was working with Telfair County Sheriff's Office. I think maybe she's only working at Telfair now. But at any rate, it was brought to her attention by a girlfriend of the defendant that he had come and had actually attempted to sell, I believe, one of the guns that was stolen out of Mr. Boyd's residence. He also had a wallet that had several different identifications belonging to Mr. Boyd. As a result of this discovery of this stolen property in his possession, investigation was done.
Okay, we learned from OJ not to bring gloves, or at least lose one or two. Now we're learning from this guy. If you're going to burglarize someone, absolutely don't carry around their IDs from their wallet with you. What? Why?
It was determined there had been a forced entry into the home while they were not present. Very close in time to this, his possession of this recently stolen property. As to count 1, It was further determined through investigation by the chief of police, of Mount Vernon Police Department, Chief Burns, that there was a incident that had occurred, at the location on the Snell residence. And the defendant actually led the chief to it. There were, doors had been kicked open, and there were some items piled up on the sofa, some guns and such. So as to the firearm by a felon, he is a felon out of Bullitt County, Your Honor, convicted felon.
Anything from the defense?
No, Your Honor.
Mr. Bryant, do you have any questions about anything that's happened?
No, sir, Your Honor.
Anything that you'd like to say? You don't have to, but you can if you want to.
Yeah, no, besides the fact that
Chitty got a new icon. I love it. Bobby, they used to say that to me all the time when I was a little girl at school. Because when I smile, my eyes go to slits. Open your eyes when you smile. Open your eyes.
tried to sell any of those items, that was false. From the girlfriend, we're no longer together, nor do we speak, but yeah, that was false. Everything else is accurate.
That doesn't really have any substantial
Yeah.
bearing on the actual charges you're pleading to, though, okay?
Yeah, understandable.
I just want to make sure you understand that.
Yeah, understood. Yeah.
Very well, the court finds that the plea has been freely and voluntarily entered, that there is a factual basis for the plea, and the court will accept the plea, and the recommendation, as was stated, counts 1 and 2 will be 15 years probation each, $1,000 fine each, and count 3 will be 10 years probation with the same fine, plus the add-ons, be served under drug and alcohol conditions, Fourth Amendment waiver conditions, no contact with the victims. Restitution be left open for 90 days. You have a period of 4 years to file a habeas corpus petition from the date the sentence becomes final, 30 days to file a notice of appeal or a motion for new trial. Do you possess a concealed carry permit for a firearm, Mr. Bryant?
No, sir, Your Honor.
All right, Mr. Bryant, that will conclude your case. Probation will catch up to you first chance they get, but good luck to you, sir.
Thank you, Your Honor.
Good luck.
All right, thank you, Mr.
This is the judge I keep talking about, or I say I don't know his name. I don't know his name. We watch him all the time. Oh gosh, Mel, are you okay? Does anything hurt? Or does everything hurt?
Zero 86 State versus Jonathan Herbert Conrad. That's you, sir?
Yes, sir.
I'll note for the record that Mr. Conrad is at the podium with Ms. Cameron. You have a plea recommendation, Ms. Cameron?
We do, Your Honor.
All right, go ahead.
Your Honor, Mr. Conrad will be entering guilty plea to count 1. We anticipate the recommendation of 20 years with 1 year to serve. Credit back since September of 30th of 2024, so he's completed that time. $500 fine, alcohol and drug conditions, Fourth Amendment waiver. Special conditions of a probation shall include anger management classes, or the anger management program that probation has, matrix classes, continue on his mental health meds and treatment as recommended, and to be evaluated for the mental health caseload. Count 2 will be null prost.
Chinny just swore at us in 3 languages, so Chinny, put that money in the jar. We apparently have a swear jar now.
Anything to add to that, Mr. Pritchett?
Did you say 20 or 10?
20.
20.
Okay.
Yep.
I had on our notes, we're
Not
doing
the
10.
Instapot.
I'm good with 20.
No.
I had
Okay.
20 on that.
Okay, I'm good.
No.
Yeah, I mean,
No, we're good.
he's up for I mean, obviously
Yeah.
he'd be up for evaluation after 3, but I mean, 20 was the agreed upon time that we've talked about the whole entire time.
All right, Mr. Conrad, it appears that you and Ms. Cameron in the DA's office have been discussing your case and have reached this joint recommendation, or a negotiated plea, as we call it. I'm going to have a lot of questions for you in just a moment, but so far, has everyone said what you expected them to say?
Yes, sir.
Before I can get to the disposition phase of this case, I have to first go through a process with you where I ask you a series of questions to make sure that you understand all the details of this plea, but just as important, that you understand all of the rights that you'll be giving up if you complete this guilty plea today. If at any point during this process you don't understand my questions or you need some more time to talk to Ms. Cameron, just let me know, and I'll give you all the time that you need within reason. Do you understand everything so far?
Yes, sir.
Please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you give here today shall be the truth?
Yes, sir.
Put your head down. Mr. Conrad, do you understand that you were pleading guilty to count 1 in this case?
Yes, sir.
And do you understand the sentence recommendation of 20 years on probation, serve 1, balance on probation, credit time served back to that date given, and all these other conditions? Do you understand all that, Mr. Conrad?
Yes, sir.
Is that what you agreed to plead guilty to before you came out here to the podium?
Yes, sir.
Before the court can decide or determine whether or not to accept this guilty plea and this recommendation, the court must
Marlene,
first
we
determine
love you.
that you are making a knowing, intelligent, and voluntary waiver of all of your rights, that you know and understand what you're doing, and that you're doing it of your own free will. So it's vitally important that you speak up if something happens that you don't understand. According to the plea agreement, we'll focus only on count 1, which is aggravated assault. That is a felony, has a maximum sentence of 20 years with a range of 1 to 20. And before I forget it, let me make sure I get this on the record. This is a Montgomery County case, but we are in Wheeler County today. Do you waive your right to have this matter resolved in Wheeler County?
Montgomery County,
What did I say?
in Wheeler County. Waive the right in Wheeler County.
Yeah, I got it backwards. It's a Montgomery County case, but we're in Wheeler. Do you waive your right to have it resolved in Montgomery County? Do you want to have it resolved today?
You want to resolve it here today?
Yeah. Gotcha.
Okay.
Sorry about that, Mr. Conrad. I got all that butchered up. I apologize about that. All right, the court does further advise you that you can't be forced or compelled to enter a guilty plea today. You can maintain your not guilty plea and have a speedy and public jury trial if that's what you wanted, where you would enjoy a presumption of innocence which would remain with you throughout the trial, and the state would have the burden of proving your guilt to the satisfaction of the jury beyond a reasonable doubt. You would have the right to have your lawyer with you at all stages of the trial, where you could confront, question, and cross-examine all witnesses and persons who accuse you. You would have the right to defend yourself and to bring into court your own witnesses and evidence in your behalf. And at your request, the court would issue subpoenas directed to your witnesses to compel them to come to court. You would have the right to testify yourself if you wanted to, but you could not be compelled to testify nor to incriminate yourself, because you have the right to be present, including the right to remain silent. You would also have the right to ask the court to suppress any illegally obtained evidence, and if the jury should find you guilty, you would have the right to appeal that guilty finding to a higher court and be represented on that appeal by your attorney. Mr. Conrad, do you understand that if you plead guilty today pursuant to this plea agreement, you will be giving up or waiving all of these rights? Do you understand that?
Yes, sir.
Fourth Amendment waiver will be a condition of your probation. Do you agree and understand that as a special condition of probation?
He does go on for a bit. I mean, we could name a swear jar, I guess. We could name one. What's a good name for a swear jar? I know. Leslie.
Will be that you shall submit to a search of your person and property at any time of the day or night, with or without your consent, or a search warrant whenever requested to do so by a probation officer or a law enforcement officer, and if anything is taken, it may be used against you as evidence in a further court proceeding. Do you understand that?
Yes, sir.
Now, you're represented here today by Ms. Cameron, is that correct?
Yes, sir.
Have you had enough time to talk to her about this case?
Yes, sir.
Do you need any more time to talk to her about this case?
No, sir.
Do you have any objections whatsoever about how she has handled your case?
No, sir.
Is this your free and voluntary plea?
Yes, sir.
Has anyone threatened you or frightened you to force you to plead guilty?
No, sir.
Other than the plea recommendation, has anyone promised you anything to get you to plead guilty?
No, sir.
Are you under the influence today of any intoxicants like alcohol, drugs, narcotics, or prescription medications?
No, sir.
Is your mind clear today?
Yes, sir.
Do you know where you are and what you are doing?
Yes, sir.
Can you read and write?
Yes, sir.
Do you have any questions about anything that's happened up to this point?
No, sir.
If you are not a United States citizen, a guilty plea will affect your immigration status. Mr. Conrad, are you pleading guilty to count 1, aggravated assault, because you are in fact guilty?
Yes, sir.
See that his plea gets entered.
I'm frightened by the swear jar.
Please be entered, Your Honor.
Facts of the case, please, sir.
Yes, sir. On September 30, 2024, Sergeant Macy Dean with Mount Vernon Police Department responded to 500 South Railroad Avenue to the Royal Wood Apartments in reference to individuals fighting. This is in Montgomery County, Georgia. Upon arrival, they were flagged down and directed to an apartment. A male came out of the apartment, was very agitated, sweaty, began yelling. When he asked what was going on, the female then exited the apartment, which actually was his mother, crying and gave the outcry that he had choked her, referring to the defendant. Then there was some arguing began, so they had to be separated. It got to the point where Officer Dean had to actually unholster her firearm, and ultimately had to also retrieve a taser and to get the defendant under control, although nothing was actually used, but did get him under control and got him to sit down, got him cuffed with the assistance of a deputy. Once detained, conversation was, Ms. Mary Powell, the victim, was spoken to, and she stated that Mr. Conrad had gotten agitated. He had not been taking his medication like he was supposed to. There was a smell coming from her freezer, and she wanted his assistance in trying to figure out what was going on. At that point in time, he got agitated with her, and began swinging and hitting her, began put his arms around her, hands around her neck, and began choking her. She acted in self-defense and struck him. There was a neighbor, bystander, Mr. Darren Berry, who also witnessed the choking.
Anything from the defense?
Your Honor, we'll stipulate to a factual basis for the plea. I don't know if I mentioned this earlier because pleas are getting confused in my head at this point in time. Also should be a provision, if I didn't mention it, of no violent contact with the victim.
Yes.
I have had contact with the mother. She's fully aware
That's
of what's
her?
happening. This is her sitting in
Okay.
the back, Ms. Powell. I've had contact with her. She's fully aware of what's happening, and part of the special conditions that are specifically referenced on there were her suggestions. So
Okay.
that's part of the plea agreement. So
All right,
she's
very
fully
well.
aware of it. So she knows
Mr.
what's
Conrad,
going on.
do you have any questions about anything that's happened, Mr. Conrad?
No, sir.
Is there anything that you'd like to say? You don't have to, but you can if you want to.
No, sir.
Very well, the court finds that the plea has been freely and voluntarily entered. There is a factual basis for the plea, and the court will accept the plea. And the recommendation, as was stated, on count 1, 20-year sentence, 1 to serve, balance on probation, credit for time served back to September 30th, 2024, be a $500 fine plus the add-ons that go with it. Be served under drug and alcohol conditions, Fourth Amendment waiver conditions, no violent contact with the victim. And these following are all specials: complete anger management classes, complete the matrix classes, mental health medications and treatment, and evaluated for the mental health caseload, all done through probation. You have a period of 4 years to file a habeas corpus petition from the date this sentence becomes final. 30 days to file a notice of appeal or a motion for new trial. Do you possess a concealed carry permit for a firearm, Mr. Conrad?
No, sir.
All right, Mr. Conrad, that will complete your case. Probation will catch up with you first chance they get, but that will conclude the matter. Good luck to you, sir.
Thank you.
We did it. We made it to the end. If you're here for court, it's over, and I appreciate you. Thank you so much for coming out. I hope that you have a great day. So I'm going to start OJ now. We'll stream tonight at 8 o'clock. I got a good one. So the other day I tried to record an attorney disciplinary hearing in Pennsylvania. And I forgot to unmute it. So I recorded the whole thing muted. And I told Zach that. And Zach just gave me the whole clip with sound. We're going to watch that tonight. And it is unbelievably worth your time to watch it. It's so good. Oh my gosh. One attorney tells another attorney to stick a objection up his ass. Just so you know, that's going to happen. So, oh man, we're going to have so much fun. And then I'm worried about OJ tomorrow. I go see a house tomorrow at 8 o'clock, and it's perfect. It's a 4-bedroom, and it's far away. We're not close, and there's nobody around us. It's a farmhouse, and there's a cemetery around us. There's corn around us, and absolutely nothing else. And, pets welcome. So, it's dirt cheap too. It's so cheap. I want to be there at 8. So I don't know if I'm going to start my streams early tomorrow morning so I'm done. I just don't see how I'll get done. I think we might have to stop OJ early tomorrow. I just think we have to. It's going to, Chinny. It's so perfect. Oh my gosh. I'm just so nervous that tomorrow's going to be too late, that I'm not going to get it. But we'll see. I mean, I'm going to offer. I've already made up my mind. I have not seen it. I've already made up my mind. And I know that's stupid. But, I mean, it really is just wonderful. It's just perfect. It's not far. It's not as far as my other options. My other options are like an hour away from where I live right now. And they're not great options. They are get me out of this house immediately options. So they are about as bad as you could think. This magical house is still in Lancaster County, which I can't believe it is in Lancaster County. But it's not near like the city or where I live now. It's far enough away in a direction that I'm not going to say. It's just, and no one will ever be able to find me. Not only that, it's like down this one long, narrow, like dirt road. So it's not like someone can come to my house and I not know. I mean, I'll just know. Yeah, it definitely has a basement and an attic. And it has a huge barn beside it. And I'm thinking, if he lets me use the barn, I don't know, and a garage. There's a huge garage beside it too. There's like a couple buildings. I think he bought the property. It's 64.5 acres, which for the girls in here is freaking huge. Okay? So it's a lot of farmland. It's a cemetery. There's a couple buildings on it. That, JK, is what I'm worried about. That is what I'm really, really, really worried about. I don't know what to do if it doesn't have good internet. I don't know how to figure it out. But that's something I will figure out. I'll stream it. Coffee shops in the morning if I have to. No, there's no way they can figure this out. From what I'm saying, there's just no possible way. I live in Lancaster County. There's freaking farms everywhere. In every single direction. Just saying there's a huge farm doesn't even tell you which direction to go in. And that, when I say that, Kelly, I mean north, south, east, and west. Actually, this might be the last place you'd think of looking for a farm. So, it is perfect. It's 4 bedrooms. There's 3 of us. So, I don't know, maybe my other daughter can move back home, or I don't know. I don't know, Mel. I'll figure it out. I really will. There might be a bumpy road when I move. You know what I mean? I might miss a few streams, but I don't know. Probably not. I'm not going to move at 4:30 in the morning. So, and I'm going to be somewhere at 4:30 in the morning. So there's no reason I can't stream. The hard part will be content. If I'm moving all day, I can't be moving all day and watching court videos for content. So we might fake a few streams at worst. Like, I'm just going to record a docket, cross my fingers, and play that for the live stream. I know what the price of the house is because I researched it. So there's a lot of scams out there when you're looking to move, when you're looking for a house or an apartment. So as soon as I saw this, I thought it was a scam right away because of the price. The price is really good. So I researched who owns the property, when it was bought, everything I could. So I know exactly who owns the property, and this is the person that I am speaking to. And I know when he bought it, I know how much he bought it for. I know he doesn't care about the house. He didn't buy this property because of the house. He bought it because of, everything else. So I think he just, this is my guess, but the property that he bought has a house on it. So I think he just wants someone there so it doesn't, get squatters or fall into disrepair and things. And, he gets rent. So, I mean, my little rent is going to do nothing to the price that he bought this whole parcel for, but it's something, right? Hi, Walter. So that's tomorrow. I have one full day. And I'm so nervous it's gonna get taken in one day. But I am gonna do something stupid and put cash down tomorrow if I have to. Yeah, he probably just wants to farm it. But if he doesn't, and he's just thinking of something else, and there's that great big farm there not being used, then maybe we could do court vibes rug cleaning videos. Did you ever see those videos? They're freaking mesmerizing, but I can't watch them anymore. If you don't know what I'm talking about, which I'm sure you do, there's these videos that you just watch people cleaning rugs with all those tools. I don't think so, because he lives in a different county. So I can't go today. He doesn't live in Lancaster County. I guess I know where he lives. But you have these videos where they use these, these tools and stuff to clean rugs. And they're mesmerizing. You can't stop watching and you don't know why. It's so stupid. But lately, all the rug cleaning videos have been extra gross. Dude, I didn't need that. Upping that up a notch was not what we were looking for. We were looking for relaxing and calm. We weren't watching these videos for shock factor. That's why we watch American Courts. We watch American Courts for shock factor. I don't know, Bill, if you're here for court, it's over. I didn't stalk him, JK. I'm just protecting myself. Because there's so many people online right now that are trying to sell houses and rent houses that are not theirs. They don't own the house. And then you give them money and then you end up with nothing. So maybe, yeah, you could do it in the barn or in the cemetery or in the house. I haven't moved in yet. So my fingers are just crossed. There's a couple things against me. So we'll see. We'll see. He looks like a good dude. He sounds like a good dude. So it's probably going to mess up our streams tomorrow. We could, because there was some good parts, Bill. There really was. There was a prostitute. There was a prostitute. Though she denies it, I think. I don't know. She never really denied it. But she said she was a dancer who lives with... Never mind. Anyway. Me too, Mel. Oh, man, it's so perfect. I'm so nervous. You're not supposed to fall in love with houses because, the chances of them still being there, blah, 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 it's a good chance I'll never get this house. A great chance. An excellent chance. So I shouldn't have fell in love, but the other options are so bad. And this is just so perfect. So we'll see. Thanks for coming out, guys. I'm going to start OJ. And yeah, I'm not going to be able to do a lot of OJ tomorrow. There's nothing I can do about it. I'm going to start OJ now, and I'll see a bunch of you there. And I'll see the rest of you later tonight at 8 p.m. Don't listen to Bill. If he says he's streaming tonight at 8 p.m., don't listen to him, because I sent you all there last week or Sunday, and you all left my stream. All of you, I saw the numbers drop. And you went looking for Bill, and he wasn't even there. So I had to delete that stream because there's only 4 total views. People who accidentally clicked on it and then went to take a bath. Me too, Mel. Me too. I'll let you guys know. I promise. Oh, man, because, my mom came over yesterday, and it was drama. And it was such drama. I asked her where my effing cats are, but she had no answer. I did not call the police. There were no police involved yesterday. But soon there will be no police involved ever. Unless I date a police officer. That's possible. Anyway. Good luck to Linus. I hope everything goes well. I don't know. It's 8 o'clock Eastern Standard Time. Yes. It's 9 o'clock Central, right? 7 o'clock Central. 7 o'clock Central. Sounds right. That sounds dead on accurate. It's fine, Nana. It's all good right now. Like, the worst is over. I'm almost at the edge. All right. I'm going to put on my thing now, and I'll see you guys in OJ. Love ya. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see